Swimming like a shark in a shrimp tank. Big fish, small pond in the shrimp tank.
Welcome back to another episode of the Shrimp Tank. We come to you virtually from Seattle and the entire Pacific Northwest. Listen, if you want to learn how to start, grow, or run a successful business, you, my friend, are in the right place. This is where we say street smarts and book smarts collide. Hello again, everyone. I'm Dan Weedin, and I'm joined by my co-host, Michelle Bomberger. But you know what? She's not really my co-host today as much as she is our guest. So she is co-host / guest with a lot of great information that I think you're going to find very interesting. Michelle, as we say, we're going to come back to you in just a minute. Everyone, you can find us wherever you get your podcasts. We're on iHeartRadio, Apple Podcasts, Google Podcasts, Spotify, SoundCloud, Stitcher, and YouTube. You know, you might say we are ubiquitous. So, I want to say that Michelle doesn't need an introduction, but I don't know, maybe there are people out there, Michelle, that are seeing you for the first time. I'm going to give my own little personal introduction of you. I've known Michelle, I think we're somewhere probably in about the dozen years that we've known each other, Michelle. And for everybody out there, if you don't know about Equinox Business Law, and we'll have a great commercial later on as a title sponsor, but Equinox Business Law is really, really a great idea in today's modern business world. You've heard about fractional CTOs and fractional CPAs and bookkeepers. Well, Equinox is a fractional business law. They are your corporate attorney on call. And I don't know, Michelle, if there's a bunch of them out there, but this seems like it's your brainchild. It's your thing. I think it's brilliant because what you really do is you're bringing small businesses, small and medium-sized business, whatever your definition of small is, I guess. But you're bringing small and medium businesses into the world of having a in-house legal counsel, right? And so I think it's great. You do so much more than that in the world of your nonprofit work. I think if everybody goes to Equinox Business Law, Michelle, and goes to the About Us, they're going to be very, very impressed. The only downside that I can see is that you are a Notre Dame Golden Domer. Other than that, you're okay with me. Michelle, how are you doing?
I'm good. I'm good. It's fun to kind of be on the other side of the mic this time.
The other side of it. Yes, I guess so. So now, I mean, this whole thing is, we're not going to do hot or not or plead the fifth. It's all hot or not and plead the fifth. And you're on trial here, so to speak. Look, you and I talked a little while ago, and you had brought this idea up that we want not to have a guest this month, but to maybe talk about something that has really kind of taken hold in a lot of the content you're creating. And it's around transparency. But and we're going to have you define that in just a second, but there's so much that this picks up. Everything, and we're going to talk about non-competes. We're going to talk about probably piracy. I have a whole, everything around contractual language and the relationship between the employer and the employee and the transparency around that. That's what we're going to talk about today, and I'm really excited. I would also mention to people, I'm going to be looking at this article here that is up on Equinox Business Law. I'm going to be using it as an example, and I love it. It's really good. It's transparency is now mandatory. Is your business ready? So, Michelle, I'm going to stop talking. I'm going to ask you, when somebody reads that, transparency is now mandatory, that's an interesting way to put it. I guess I always thought transparency was important. Maybe it always has been, but talk about the definition of transparency in this case and what mandatory means in that regards.
Yeah, this is something that it occurred to me sometime last year as we were seeing specifically employment regulations, but it's even broader than that. The new Corporate Transparency Act is another example of this. And it feels as though we have more and more demands on business to share information. to disclose information. And the things that we used to rely upon as business owners, things like non-competes, things like NDAs, things like don't talk about your salaries, those types of things that have historically been tools that businesses have relied upon to retain and keep secrets and prevent their reputation from being sullied, are now things that they can't use anymore. Those tools are no longer available. And instead, there's more of a demand for sharing. So pay equity is a great example of this, and corporate Transparency Act is another example of this. And so how do we as business leaders figure out how to comply, but then also to protect our businesses? Because these things that we've typically relied upon are no longer available. So
Well,
transparency is really that.
Yeah, quick question on that. Was there a catalyst to this? Because we're about the same age. I remember getting my first job in 1987, for goodness sakes, but I remember the 90s and the 2000s. It seemed like non-competes and all of that were all in vogue and everything you talked about. Has there been a catalyst that has been moving this in a different direction?
I don't know if there is a single catalyst. I do think that you saw certain states that have a progressive stance on employment matters, California being sort of the prime example and maybe the first mover in this space, that you started to see states as, independent jurisdictions move toward employee protections. And so, what California starts, Washington then, picks up as well. So Washington's had a lot of this. Oregon, Colorado, in the last 18 months or so, did a major overhaul on their employment laws. And then you have some other scattered states that are doing that. What we are seeing is the federal government also coming on board. And I think that is definitely a shift, because a lot of states, consider this a states' rights issue. When you get into the legal constitutional issues, sure. Is this a states' rights issue, or is this a interstate commerce issue? And I had heard an article about this topic that the FTC is looking at it from their non-compete ban, specifically looking at it as a restriction on trade, and the amount of economic impact there is in keeping people from being able to move out of their jobs and into better jobs is actually impacting the overall economy and interstate commerce. And so that's where the kind of their baseline for why it should be allowable. So while maybe not one single catalyst, it's been a trend over the last 10 years or so.
Well, as you say that, and I think about interstate, and you talked about, interstate commerce, but the hybrid, the virtual worker, because I live in Washington, but if I was, say, I could be employed by somebody in South Dakota or Florida or heck, anywhere in the world, but let's just use the United States. Is that a driving factor where the federal government could also say, hey, look, you have employees, you're a small business, you may only have 30 employees, but half of them aren't in the state you're in?
Yeah, I think interstate commerce is so much broader than that, there's probably a lot of reasons why that could fly as an economic interstate commerce issue. Typically, if an employee is working in a state that's different from their employer's kind of home state, the laws of the state where the employee is working are going to apply. And so that raises interesting questions about where should I be hiring, where should I not be hiring? And the company is typically required to register in those states as an employer in those states. So it's become a really interesting kind of patchwork of rules, patchwork of how do I, as a employer with employees across the country, which is pretty common these days, how do I understand what the requirements actually are and manage my business so that I'm in compliance?
So I'm looking at 4 areas. And again, it's a really excellent article. It's under Equinox Business Law, under their blog, mandatory transparency readiness. There are 4 areas, and I want to talk about each of them. Before I do, though, the first part of the article talks about pressures, that the pressures that business owners are facing. I guess my question before I dive into those is, do business owners really feel the pressure? Is this something that they are more aware of, or is it kind of coming in the back door and they don't know it yet?
It's a really good question. I think that the pressure is to some degree the lack of awareness, right? The fact that they are blindsided and they know they're going to be blindsided again and again and again. And so I think that pressure comes from the, sitting somewhere in the back of your mind that there's something that you're missing. So I think that's one thing. But I think the more kind of obvious and concrete thing is that because these laws are out there, because these laws are now on the books and employees know about them, it's not only that you're required to do so because of the regulation, but you're also being asked more questions, and the prying and the intent of the employees is to know more as well. And so, for example, in Washington pay equity, businesses that are smaller than 15 employees are not required to comply with the job posting requirements. However, if all the other job postings out there have this information and yours doesn't because you're under 15, there's a lot of employees that are just going to skip over it because the information is available from other people. And so do you kind of by default have to participate in order to get the candidates interested in your role? So that's pressure. And I think there's just overall administrative burden and pressure in complying and maintaining kind of your awareness and your compliance.
Okay, we're going to dive into this non-compete first, because I think people understand the terminology. When I joined the first insurance agency I started work with, I signed a non-compete agreement. And I do remember it. It said something to the effect of, if I left the agency, didn't say I could never sell insurance again, but I could not sell insurance within, I think it was a 30-mile radius. Now, 1989 was a different time, and we understand how all of that worked. But I mean, I was limited by radius, and there was a non-piracy part of it that I couldn't steal, my own clients back because the agency owned it. Talk about what people should know about non-compete. Is non-piracy a part of that? Can you talk about that segment?
Absolutely. So I'm going to clarify non-piracy as non-solicitation, because that's often how it's framed. But just for clarification, and I also want to clarify the difference between the two, because I think it's a pretty common confusion out there. So I think you described it well. So non-compete is that you cannot take a job that competes with the business that you're working with. And then non-solicitation is you can't call on customers and or employees of the business that you're leaving. Now, the interesting thing is that non-solicitations have gotten so broad, where a lot of times it says you cannot solicit, which is common, right? Induce them to change their behavior or, leave the business. Again, very common. But then you start to get into, you can't communicate with, or you can't do business with this customer. Or you can't, I've actually seen, connect with them on LinkedIn. And it's like,
wow,
are you kidding me?
Wow.
And so the breadth of this is extensive. So it's one thing to say you can't go call all the customers and ask them to leave.
Right.
Most people would say, okay, that is a reasonable request. But that if they call you, you can't work with them. That's a maybe less reasonable request, but I get it, because you can't tell. I mean, how often does it happen? Like, well, I can't call you, but if you call me, it's okay, right? Like that happens all the time. You
meet on the golf course or in a bar, and it's, hey, we're just getting together, and there's no microphones.
So you can, as a business owner, and an employer, you can see why you kind of want to buckle up these things, right? But ultimately, it's become so broad. So I kind of distinguish those two things because I think that they're important to note, and then to kind of talk a little bit about why non-solicitations are kind of on the chopping block as well, because they've gotten so broad. So, again, California has totally banned non-competes. It's kind of an easy one because they're just banned. Washington, because we are in Washington, did reduce or restrict the availability of non-competes to people who make a certain salary, and that salary range, that salary threshold increases annually based on a cost of living adjustment. So something in the $120,000 to $130,000 that is, anything below that, it's prohibited. Above that, it's got to be within certain limitations. And Oregon, Colorado have similar type structures as well. And Washington has an amendment that takes effect on June the 6th. So that's coming up. And that actually folds in this non-solicitation component. And so there's some amendments that they're doing to help clarify Washington's rules. And we have a blog post on that as well if you want to learn more about the specifics. But on top of that, we now have this federal ban. So the federal ban was approved by the FTC in earlier this year. And of course, it's subject to legal challenges right now, but it should take effect in early September. And that is a national ban on non-competes. Basically, no new non-competes can come into effect. And non-competes that are existing for people who are under a certain salary threshold, what they're calling senior executives, are void. So basically, non-competes are kind of
So it goes
going
back. It takes
going.
it goes. Wow, that's interesting.
So, and nothing new is allowable. And so there's rules around all those things. The federal one does not address non-solicitation specifically, whereas Washington's does and some others do. So I think overall sort of message here is that every state is a little bit different. The federal ban has some requirements, but the state ban or the state restrictions might have some unique elements that patchwork on top of that. Right. So California might be even more restrictive than the federal one. Well, California's is going to rule, right? And Washington's maybe more restrictive with respect to non-solicitations. And so it would have to be paired up with the federal one. And so it's not just a blanket do this to everything. There is a strategic and thoughtful tactical component to go with it.
I'm thinking that we could probably do a whole podcast just on the non-compete and non-solicitation. But let's move to the second one on the article, which I find interesting. Find all of these interesting. It's the non-disclosure and confidentiality provisions, and you talk about Washington's Silence No More Act. I did not know about that act. I don't have employees. Can you talk about that segment, and for those people who don't know what Silence No More Act is, talk about that as well.
Yeah, and something to keep in mind with Silence No More, it's not just for employers. It's actually kind of across the board. All non-competes or all non-disclosure provisions, confidentiality provisions should have this carve out. And the purpose of it makes a ton of sense, right? So again, we have relied upon the ability to, shush people and keep bad acts sort of under, sweep them under the rug. Good examples are, the Harvey Weinstein situation, the Trump hush money scandal. All those are great examples of how this works, right? So in order to keep my reputation and to hide these events, we're going to pay some money, and you're subject to a confidentiality agreement. So what Washington put in place a couple of years ago is a requirement that those confidentiality provisions, while they can still be quite broad, they must carve out and allow for the disclosure of bad acts by the employer. So if there is, discrimination, harassment, assault, anything like that, is a carve out from the non-disclosure, and people can talk about those things. So
it's almost like a whistle. It's almost like a whistleblower type of a scenario where somebody is calling out bad behavior, bad actor, bad situation, and can do so without fear of retribution.
That's right. And actually there's yes, they're legally allowed to disclose that regardless of whether they have signed it. And with that particular law, if you present a non-conforming NDA or confidentiality provision to an employee, they're entitled to $10,000 like that, simply because you gave it to them. and it was violating. And so this is, as you mentioned, you didn't know about it. It's pretty common that people don't know about it, and lawyers do. And so if you have your employee, who you're hiring, you give them the document, they take it to their lawyer, it wouldn't be unheard of for them to come back and say, well, since you gave me this, I'm entitled to $10,000.
Before we go to a quick break to hear more about Equinox, this might be actually a really good segue. I've got to believe that HR departments and HR consultants and people who are in HR and staffing and all of that, they are familiar with it, correct?
I would think so. I mean,
I would think so too.
Yeah.
The reason I bring that up is everybody should have a corporate attorney. They should have a corporate attorney on staff, in-house. That's what I was going to say, an in-house attorney. And that's what Equinox does. So we're going to take a quick break to hear more about Equinox and their strategic legal counsel for all. We're going to do that right now. When we come back, we're not going to do plead the fifth or hot or not. I'm just going to throw my best stuff at Michelle. Don't walk away. We'll be right back with more of the Shrimp Tank.
At Equinox, we believe in the power of law to give business leaders the freedom and confidence to go boldly into the unknown. Entrepreneurs don't trust that lawyers can be affordable, accessible, or offer a strategic advantage. Law feels like a complicated cost that only the megacorps can afford, so they often go at it alone. We imagine a world where entrepreneurs have the same strategic advantage of law as the megacorps. Equinox makes it possible for all business leaders to have a general counsel on their team to support both strategic and tactical legal needs, knowing where you've been and where you're going, and guiding you on how best to achieve your goals, while protecting what you've built, with an all-inclusive, fixed-price legal solution tailored to your business. There's no more worry about how much legal will cost or if you'll even get a response. Instead, you have a relationship with your legal team, access to legal support whenever you need it, and the freedom and confidence to take your business boldly forward. Our relationship starts with a complimentary business health assessment. Complete the 5-minute survey at equinox.law, and you'll immediately get a 30-page report to help you and your team prioritize the legal infrastructure you need to move your business forward. Plus a complimentary consultation with our corporate counsel to walk through the report together and understand what your business needs now and for its future. Now's the time to invest in your business and go boldly forward with legal on your team. Equinox Business Law Group, strategic legal counsel for all.
Welcome back to the Shrimp Tank. We're really having a lot of fun with my co-host, Michelle Bomberger. She's on the other side of the microphone today, fielding questions for me, but I think these are really, really important questions for small business owners, their employees, and their trusted advisors, whether it be legal counsel or HR or whatever it is, because these really apply. And I'm really looking at this great article that's under blog, under mandatory transparency readiness. We've hit on some of the pressures that are facing small and medium-sized business owners. We've talked about non-compete and non-solicitation. Non-piracy must be an old school term, I guess. I that's all I remember.
Maybe.
Yeah, and we talked about non-disclosure just right now, and the silence no more. Have two more I want to pick up on. Pay equity is the first one. You talked about pay equity is another trending area demanding transparency. As you mentioned earlier, I think this is part of it. Part of it might be, oh, Dan, I'm going to pay you X amount of dollars, but you can't tell anybody how much in the organization, how much you make, right? Is this part of that?
No,
No.
it's actually different. So for many years, and this is really related to concerted activity and collective bargaining, you're not allowed to prohibit someone from talking about their salary or any other factor of their workplace. So that is actually different. And there are trends in that area as well. No question about it. With concerted activity, there are some recent opinions that shift the burden on the employer to show that their policies are absolutely necessary, with the assumption that the employee is dependent on the employer, and the employer, any any restrictions or policies they put in place are harming the employee. And so that's a whole nother conversation.
Okay.
It is also quite interesting. Pay equity is really about, again, transparency in the area of pay and benefits. And so the idea that certain demographics are getting paid more than other demographics, typically gender or male-female orientations, and creating the obligation of the employer to have pay scales in place, documented pay scales, and for larger companies to even have that across the organization around roles. So Washington has this, Colorado has this. I think Colorado was first, but it's for companies over a certain size, they are required to disclose the pay scale, the range of the salary, and all the benefits in a certain degree of detail in the job posting. And so that will create the ability for us to come to the table with the same standards, regardless of who the candidate is. That is the kind of the key point there. The challenge, one of the many challenges, again, I talk about the pressure on businesses. One of the challenges is, especially with the wage appreciation that we've seen in the last number of years, you might have somebody who's sitting in that role and they now see a job posting for the same role at a 20% wage increase from what they're making. And so it's required businesses to not only address the pay disparity across different demographics, but also how do I deal with current employees in the same chair who are making less than new employees in the same chair, and how do I communicate that to those folks so that there's transparency and fairness. And oftentimes it's going to require you to give a pay raise to those individuals who are sitting in those roles.
So that, that's interesting. As I was listening to you talk about that and just kind of glancing a little bit more at the article, I was going to ask, how does that deal with promotions and pay raises? What you're saying is there's a fine balancing act based on is it just what that company is doing, or is there something to do with the competition and let's just say certain job, certain role 2 years ago was X, now it's not going to be 2X, but let's just say it's an increase of 20%, and somebody else is putting that. Is there a pressure for companies to, I hate to use the word keep up with the Joneses, but keep up with the increase, and that employee might be due an increase in pay, even to keep them in house, because maybe they're looking around and they see somebody else has more. I mean, there's a lot of moving parts in that, right?
There is. It's super challenging because, again, we could kind of hide behind this before, right? We could hide behind the fact that we were paying less or paying more. And now it's all out there and employees are all seeing it. And so they're demanding it, right? So the employee is now able to come in with the information, not only about your job posting, but other people's job posting. And again, if your job posting doesn't have it in there at all, they might just ignore it because they're not going to call you and ask, they're not going to take the risk, perhaps. So thinking about how that plays in across your business and others, because now we've got that information, and then within your employee structures as well. So the power that the employees have makes a lot of sense. And then I think the discipline that the businesses have to put in place to be consistent in how they apply these rules, right? So promotions, well, this person, we think is doing a fantastic job. We're going to give them a, 15% pay increase, but that takes them above the band for this role. And not every company is required to have bands in place. Larger companies are. But thinking about what does that mean from a fairness, and ideally getting people to think about whether they have an implicit bias in their process, because it's out there. There's no question that it's out there. And so the hope is to reduce that by creating some standards and,
Well, what pops into my mind all of a sudden is, and we've all seen it before. Hey, Michelle, I really want to keep you, and I'm gonna increase your pay, and it goes beyond that band, whether they have a band or not, because I really want to keep you. That's another tricky part of that. One other question before we go on to concerted activities. So I want to hear more about your definition of that and how that works. I just wonder, it makes me think is that the technology through job seeking platforms like Indeed, that probably has had as big an effect on pay equity and transparency as anything else, or what do you think?
I don't know. I fortunately have not had to be an employee or a candidate looking on Indeed for
Right.
jobs. So I don't,
I was
I don't
just wondering,
actually know.
I would think the job descriptions and
Yeah.
roles and pay areas, I'm the same, I haven't, but I would have to, I would have to think that that's part of what people are looking through, right?
Certainly. And now again, because it is so available, I imagine you can search on that as well.
Sure.
The same way that you can search on titles. And so, the employer has to be really aware of what they can disclose to tell their story about why this company versus another company, right? If I'm
Yeah.
paying less, is it, am I telling a story about flexibility or hybrid or, remote or other benefits that I offer? Because we have to be able to attract people, as small businesses, especially when we can't pay those high rates necessarily. How do we tell that story about who we are and why they would want to come work for us?
Yep. All right. Concerted activity. That's I don't know why it sounds like a legal phrase to me of some sort.
It is.
I'd not heard that before going in there. And it says most business starts out, I love it. Most businesses don't really think about concerted activity because they never put those words together. What is concerted activity, and why is it that small business owners and medium-sized business owners need to know about it?
So I would put it in the context of unionization. So unions in businesses is sort of where it comes from, and employees um, under the National Labor Relations Act have the freedom to talk about their workplace and the freedom to collective bargaining, to come together as a group to improve their work environment and situation. So it kind of sits in that space. I think a couple things are really interesting right now. One is the increase in union activity. So I think it was a big thing, certainly in the pre-1980s, it was a very big topic. And it certainly continued to exist in certain sectors. You still see it in construction and manufacturing and government workers and teachers. There's still unions, no question about it. But I think in recent years, what you've seen is it's showing up in more of a kind of consumer-focused environment. So you see it around Starbucks, and you see it in hospitality a lot, kind of just cropping up more often. And so that is just something to be aware of, and ensuring that, if you are in a space where it is likely that your managers know how to address it, because you can't just tell union representatives or individuals in your company who are interested in collective bargaining and unionization. You can't just tell them to go away. There's definitely rules around what you can and can't do. And so if you're in that space, it's really important to kind of pay attention, because this is something that is becoming more visible. And again, I go back to, the more it becomes visible amongst young people, for example, and they want it, the more likely you're going to see it kind of crossing into businesses that maybe weren't on the radar before. So that's one area. But the second area that is more widely applicable is the what's called the Stericycle decision. And this was a decision that goes back to what I said earlier, which is rules and policies will be construed to the employee's benefit. So what it really requires is that employers go back and look at all of the policies they have in place and ensure that there is a legitimate business reason behind it, and that it doesn't harm the employee otherwise, right? We've had clients who come in with employee handbooks that every single time something bad happens in the business, they add it to their handbook. Every time something the owner doesn't like happens, they add it to their handbook. And so there's all of these really constrictive policies that are more just irritating to the employer than they are policies. And so they are restrictive on the employee. So someone like that would really need to go through and pull out all of these things that are restrictive for no apparent reason other than the employer is irritated by it. And so scrutinizing policies to make sure you're not overstepping is really the core of that. And it's a pain, but it is at the core of what Stericycle requires.
So we've gone through the four main. I've got some other questions that have come from this that if I was somebody who was hiring people and employing people, I think I'd probably want to know in the hiring practices, because I've had to deal with that in my world with talking to people about employment practices, liability, and how important hiring practices are. I think, at least it feels like in days when I was being hired that there was a lot of secrecy around what questions are asked and who won the interview, and the meritocracy around that and who got what. And is it, who knows who, or all of the line. Is there increased requirements for transparency in small businesses? Because I know that there are in larger businesses. At least I think I do. Maybe I'm wrong, but where does that happen? And what do employers need to be thoughtful of when it comes to hiring practices?
Well, I mean, I think the core hasn't changed in recent years, meaning that, focus your questions on the requirements for the job, right? Avoid questions that are going to put you into protected classes. So, family matters,
Right.
children at home, disability, like all of those kinds of things.
Right.
They're not necessary information to understand whether the person is capable of doing the job. And so avoid those, certainly. I would also say that there's probably a lot of folks out there that are, searching their candidates on social media and trying to understand what they can, learn about that person based on how. And that is definitely a no-no, in that if you think about all the things you don't want to know about a candidate, social media is where you're going to find it, right? LinkedIn might be the exception because it is more of a business platform, and you can see, for example, I use LinkedIn to see what kinds of companies or voices they're following. Are they interested in small business? Are they interested in entrepreneurship? Like, what are the things that they're most interested in? But even that could be on the line, right? I mean, I could learn something about their, religion or sexual orientation or family status that is something that I shouldn't know in the hiring. Right. So I think that continues to be issues that you want to be super, super careful about. And beyond that, I mean, there are definitely processes that have changed. So, for example, many states have a requirement that you can't ask about criminal convictions up until a point. So you can't ask that on the application. You can ask it after the second round, for example. And then there's definitely notices around some of these new things, such as non-compete. You have to notify them that they're going to be asked to sign a non-compete by a certain point in time. Otherwise, you can't add it at the last minute as part of the final sign-on.
Well, that was one of the things I was wondering, because like I said, I remember the days when I was being hired to be an insurance agent. That was pretty much up front in that conversation. So yeah.
And that is definitely best practice. And now it's codified in most of these.
So after all of this we talked about, now you got a whole bunch of now they know the pressure. What have you seen that small business owners aren't doing, but they should right away to at least help them get other than hiring you, right? Because they should do that. But what are some of the things that they should be doing now that they're not?
Yeah, I mean, I think finding a way to stay on top of this is really important. So are there, newsletters from, HR organizations or legal organizations or even the state that you can get and make sure you read through to see what's coming down the pike? Because I think these things don't typically change overnight, although a lot of them have had a fairly short runway for when they get passed and when they get implemented. So finding a way to stay on top of it, I think is really important. It's if you haven't had your HR, your employment processes or documents looked at in more than a year, it's probably a good time to do a full audit of that. And I know that feels very overwhelming. But there's been enough change in the last 5 years that having a full view of, even things like, does your application have have you been convicted of a crime? If you have that, I mean, that's been on the books for a while. Getting that stuff cleaned up, it's a good time to do it because there is so much change and people are paying attention. You have plaintiffs' attorneys out there looking for job descriptions that don't have the requisite pay equity requirements. You have folks out there looking for non-disclosure agreements that don't have silence no more carve-outs. Like it is out there in a way that is so easy to grab a hold of that you are going to be on the radar if you're not doing it properly.
Okay, Michelle, I have two questions left. One serious one and one fun one, because I'm going to plead the fifth on you. I lied to you. I am going to do a plead the fifth on you. So that's the second one. Crystal ball time, though. Serious one. Crystal ball time. Things seem to be moving at rapid pace everywhere. And I think technology has been the leader in that. And when you and I have been interviewing other guests on this podcast, it's one of the questions we ask. Crystal ball time. What are some areas around transparency that we haven't talked about, but you can see emerging maybe from California or maybe just from your experience? What's coming?
I think, well, the Corporate Transparency Act is one that we didn't talk about. And so that is a filing for businesses that any business that is in existence as of January the 1st would need to file by the end of this year. So if that's not on your radar, make sure that's on your radar. So that's one, and that's for smaller companies. So take a look at that. Data privacy, of course, is an enormous one. It's been going on for many, many years, but in a very patchwork format. We don't see in the United States right now any real path toward a federal law. So now it's still a patchwork of requirements, and every state's requirements are different. And not all states have requirements, but the ones that are unique to that state. So that's another one to keep an eye on. If you have people using your website, if you have people engaging with your website, if you're collecting information from users online, all of those things are going to be categories that are going to trigger data privacy. And then I think, of course, AI, right? That's one that it's trending. We know that the best solution is for us to have some sort of guardrails around this, whether the guardrails are going to actually be something enforceable or something that we can do anything with. But the, awareness in your organization of AI, what is acceptable use, what is not acceptable use, creating policies is something really important, because you should assume that your team is using it.
Yeah.
We just don't know how they're using it or whether they're using it in a responsible way. And you want to lead. You want to lead as a business leader. You want to be the one who says, hey, this is something that we, are using, aren't using. Here's how I want to encourage it. Here's how I want to limit it. And if you're silent, you just don't know what's happening. And so I think we're going to see, I think we're going to see some guidance coming out, but it's probably be a while before we have something that's standardized. And so I think as a business, it's worth investing in that and taking the lead.
It's so funny when you mentioned that about AI, who's using it and who's not. It made me go back in time. I'm going to say 10, maybe 15 years ago. Remember when employers would say, hey, no social media. You can't use social media or look at it during work time. And they were thinking about like on your desktop, but all the employees had it on, or they were
Yeah.
shopping on it was eBay and things like that. You can't do it. Well, they were still doing it. And I just had that flashback. Okay, here's the fun one. Plead the fifth. You get one plead the fifth. It's a fun one. I promise it won't be hard. Well, maybe. You've been doing a lot of traveling because I stalk you on Facebook as well. And I see some of the amazing, remarkable places that you have seemed to have gone, at least recently. If I can put you on a plane right now and you can choose any of the places you've been to, let's just say in the last year,
Ooh.
where are you going right now? It can only be one place and you get to stay there, I don't know, 4 days and 3 nights. Okay. You get to go. Where are you going?
Okay, so you've qualified this to the last year, not anywhere in the world, anytime in the future. So,
No, I want to know where you would make a return trip to.
yep. I would go back to South Africa because I would do safari every single year of my life if I could.
Wow, that's great.
Yeah.
That's great.
So we were in Cape Town for the Entrepreneurs Organization Global Leadership Conference last year. And I didn't get a chance to see a ton of Cape Town. We saw the wine region, we did safari, and then we were in conferences while we were in Cape Town. So I would love to see the city a bit more. And then if we're sticking with South Africa, I'd love to see Johannesburg as well. I didn't make it there. So that's where I would go.
What was the funnest animal that what was the most, I mean, what was the one that you said, oh my gosh, it's
You know, it was an experience more than an animal.
okay.
So we saw this leopard, and the tracker said they saw the leopard, female leopard and cub, their paws next to each other on the track. And the only reason they'd be walking like that is if she had made a kill. And so we went hunting for the kill, and we found the leopard and the babies, and the dead impala or gazelle or whatever it was, as they were like munching away at it. And they said, tomorrow morning we'll come back and she will put it up in the tree. So the next morning we went back and the animal was in the tree. It was just out of this world to sort of see that.
Oh, cool.
Experience. One, the fact that they knew that and they could basically smell the hunt, and they knew where they were going to find it, and then to see the little, the cubs like munching on this animal, and then the next day have it in the tree with the hyenas all underneath waiting for something to drop for them. It was just kind of circle of life.
Yeah, like what we see on a Disney movie, although the impala was not the car, right? This was the actual animal.
That's right. That's right.
Okay.
That's right.
Anyway, hey Michelle, this has been a lot of fun. Next time I see you, you'll be back on the other side, peppering people with questions. But I think this was a great show, and I learned a lot, and I know that our other listeners and viewers did too. So thank you for being on. Before I do go, I'm going to ask, as we always do. This is not usually my part, so I almost missed this. Tell people. When you go out of contacts, all of a sudden, tell people how they can contact you.
Yeah, and I was doing our finger.
Yeah, I
finger
saw it. That was good because I almost forgot.
Because I do want to add here that everything that is said was simply for discussion purposes. This is not legal advice. There is nuance across all of this, and it's again state specific, business specific. So this is not legal advice, but simply general information for purposes of education. And hopefully you learned something today. Would love for you to reach out. Feel free. Our website is equinoxbusinesslaw.com. We have a business health assessment on there. Feel free to take that. It gives you a 30-page report on how you should be thinking about some of these areas of your business. You can also reach me on LinkedIn, Michelle Bomberger, and Equinox is very active on LinkedIn as well, with our newsletter available through that platform too. But yeah, feel free to reach out in any of those ways, and we'd be happy to chat more.
All right, Michelle, thank you very much. Everybody, make sure you check out all the replays at shrimptankpodcast.com/Seattle and wherever you get your podcasts. We are all over the joint. We're ubiquitous. Please follow all of our show's social media pages on YouTube, Facebook, and Instagram. I believe we are on a 5th week of May. I think we have 5 weeks, so we don't have a show next week, but we'll be back the week following. In the meantime, be safe, be well, and be prosperous, because until next week or 2 weeks from now, the shrimp is back in the tank. So long.
I've been feeling like a shark in a shrimp tank. Big fish, small pond.